Ma'am, good evening, ma'am. We will start the program, ma'am.
Fine, sir. We can do it.
Okay. Very good evening to all the participants. Welcome you all. Fourth session, last session of 2 days FDP on entrepreneurship, innovation, and IP. For the last session of the second day, we have with us Madam Latha from IIT. Madam is the women scientist, TIFAC, KIRAN, IPR. Madam is also one of the registered patent agent. Madam completed his B in computer engineering and ME in computer engineering, and also Madam completed a postgraduate diploma in intellectual rights from National Law School of India. And after that, Madam served as faculty in Prince Sri Venkateswara Engineering, Padmavati Engineering College for around 2 years. And then Madam joined the IIT as a woman scientist in TIFAC. And Madam is presently the intellectual property analyst of the Indian Institute of Technology. Madam's skill sets are patent strategy, patent applications, and all. And Madam is also a registered patent agent. So, Madam has a vast experience on the patent side and the entrepreneurship. So, today's topic of Madam's session is the role of patents in the entrepreneurial ecosystem. So, we learned that Madam is a very lot of experience in that field. On behalf of Murugappa Polytechnic College and on behalf of the Department of Mechanical Engineering, we extend our sincere thanks and a welcome to Madam. And also welcome all the participants for today's session. Hope you will get a lot of useful information from Madam's session. And I request all to gather as much as information from Madam's session. Thank you, Madam. Thank you very much for joining us. And now the session is yours, Madam. You can start.
Thank you, sir. Thank you for the wonderful introduction. The session now. Hope my presentation is visible to everyone.
Your screen is visible, but the presentation is not visible.
Is it visible, sir?
It's just opening. You can go to the presentation, ma'am. Your screen is visible. Intellectual, yes, ma'am. Now you can go for presentation mode. Okay, ma'am. It's visible right now, ma'am. No issue.
It's visible, sir.
Yes, ma'am. Visible, ma'am.
Yeah. So before beginning into the session, I'll have a few words about myself. As sir introduced, I'm working in Indian Institute of Madras as one of the women scientists and also an assistant manager.
Dear participants, kindly mute your mic. There is a disturbance. Dear participants, kindly mute your mic.
Yeah, I'm working in IIT Madras. as an assistant manager and also a women scientist in part of an IP division of the TIFAC. And mainly in IIT Madras, we handled the patents, copyrights, designs, and trademarks. These are the 4 major categories of IPs we focus. And also in IIT Madras, we have a vision of one day a patent. And also we have a vision of 100 startups per year. So we are working towards that goal. So just I'll move into that session. Yeah, is it? Hello?
Yes, ma'am.
Yeah, no, I had some disturbance, sir. Is it my voice okay or it's echoing?
Yes, ma'am. It's clearly audible.
Okay, let me move into this session. So what is intellectual property rights? So what is intellectual property? In one word, I can say it as it's an idea or expression. It's your it's your idea or expressions. And that is called as your intellectual property, something coming out of your mind, something called as creation of your mind. It's called as an intellectual properties. What is that creation called? It is called as an invention, which can be a product or a process which you're designing. It can be a design of one product. It can be some symbols, brand names. It can be a software code. All these are called as a creation because you create it. And what is the right? So right is here, we call it as a legal right, which you get the ownership of your intellectual property and you can prevent others from making use of your intellectual properties. So this is the how we define as intellectual property rights. And these are the different types of IPRs we have. And this is a non-exhaustive list. One you have, first one is a patent, second one is design, copyright, trademark, GI, plant varieties, semiconductor layout designs, traditional knowledge, and trade secret and data. However, data is not an IP now, but there are plans. Government is in plan of bringing data as one of an IP, because you will see, because now most of the works is only in the data. Even if you take a computer field, we deal with the data. If you take a life science field, you deal with the data, right? So since the data plays a major prominent role in your any kind of works, so the data is also going to be treated as an intellectual properties. And there's a talk going on to include data as an IPR and how to protect it under legal statute. So let's move into patent. So anyone knows what a patent is? Anyone has filed a patent?
Yes, ma'am. Yes, ma'am.
Anyone, like, can you all define patent, or for what the patent is usually given?
Ma'am, patent is usually used for innovative ideas, and it may be in prototype, like that, ma'am.
Super. Thank you, sir. That was very nice. Any innovative ideas, you can call it as a patent. These ideas can be either a product form or a process form. So you'll design a product that can be protected under patent, or you will have a process to achieve some product. That process will be unique, but the product will be a known product. So that also can be protected as a patent. So this is an exclusive right which you give it, which we get it for an invention, and that invention can be either a product or a process. And this, by getting this right, what is the benefit you people are getting is you can make use and import your products or products made out of a particular process, and you can exclude others. Since I'm excluding others, it's called as a negative right. So it's a monopoly right, which I'm getting for a limited period of time, which is for 20 years. So after 20 years, your patent will go into a public domain, and anyone can make use of your invention, and they can build on it. Either they can manufacture it, or either they can build on it. So you get only a monopoly period for 20 years, which is a very limited period. So there's, I think everyone know this is called, we call it as a safety pin. Do you think the safety pin is patented?
I think yes, ma'am.
Yes, this was like one of the earliest patent in US. And if you see, it is, if you see the US patent number, it's itself, it's 6,281. And there's a story behind it also. So this person called as Walter Hunt, he was just taking a wire and twisting it at the end. He was trying to thinking about something, and he was twisting at the end, and he was latching it together. Then what is the purpose of the safety pin? It is going to hold the, it is going to hold some things, right? So he, when he latched, he felt it can hold some things. So finally, what happened? He patented it and he sold his invention for $400. Actually, he was in a debit for $15, and he sold the patent to the same person who he owned the money for $400. Similarly, why I'm saying the safety pin example is your invention, you may think like your invention maybe has to be big to be patented. It has to be a groundbreaking technology and it has to be very big. Nothing like that. A very small improvement over the existing thing, which is very useful for the industrial purpose and for the public purpose. Definitely it can be patented if it follows some patentability criteria. So if you think of this, you know, this is the Coke, the can opener, and the second patent is a hair clip, and third one, can you all guess? It's a ballpoint pen.
What,
It's a
ma'am? What,
ballpoint
ma'am?
pen. It's a ballpoint pen.
Okay,
Yeah.
okay.
So by looking at this, you may think it's a very small invention which we are using it in a day-to-day life, right? So these are few examples where you have to think whether your invention may be a small or it can be a very big, but our duty is to protect the invention. So you have to make sure you patented it before anyone make use of it. So the next, in patent, you've got three important criteria for a patent to be granted. One is the novelty, and second is the inventive step, and third is the industrial applicability. So when you have a novelty, which means it has to be very new in the market. So it should not be disclosed anywhere in the public domain. So, for example, like as a staff, you will be making, as a staff and student, you will be making some journal publications. So when you all make the journal publication, your journal publication itself will be a prior art for your patent, because your invention is already published, right? So make sure you always protect under patent and then go for their publication. And the second is called as an inventive step. What is inventive step is, you will have a problem statement, right? And you will have a solution for it. So the problem statement is something which you will identified in the existing technologies. And your solution will be some technological advancement over the existing ones. That solution has to have some technological advancement over the existing solution. That is called as your inventive step. And third one is your industrial applicability. So it has to be manufactured in a large scale, and it should be useful for the public. So that is your industrial applicability. Like any doubts in patents or something? Can we move on to the next?
Okay, ma'am, you can move.
Yeah. Second one is called as an industrial design. So what we protected in the patent is your functionality of your invention. Say how your product is working, how the product is being arrived, what is the process you are following to arrive the particular product. The functionality aspect is being protected in your patent. But here in industrial design, only the look and feel of your product. Say I've designed a mobile phone. The functionality is already known, so I can't go for a patent. but the mobile phone it's very aesthetically very good. The feature of the phone or the configuration and the camera placement of the cameras is very appealing, eye appealing. Then I can go for an industrial design. And this is mainly judged by the eye. Only it has to look, the finished article has to be very appealing to the eye. And the validity of the industrial design is for 10 years. You can also renew it for the 5 more years. So total validity, you can get it up to 15 years for the industrial design. So the patent is functionality, and here the aesthetic part of your aspect of your invention is protected under the industrial design. And the next one is copyright. And the subject matter of copyright is you have, it's called as a bundle of right, and you have many things which can be protected under the copyright. Your literary works, so your journal publications, your software codes, any books, all this can be protected under literary works. Your paintings, your artworks, all this will be protected under your dramatics. And your musical lyrics, all this will be protected under musical copyright. And the cinematography part, it can be protected under your cinematography. Even your sound recording part can be protected under your musical part. And there are many rights associated with your copyright. Once you register the copy, once you register your work, you have the right to reproduce it. You can translate it from one language to another language, or if you have written a storybook, a script, it is in a novel format, you can adapt it to a TV serial or a movie. So for you adaptation, and also you can distribute it. You public distribute it, and also you can publicly communicate it to the others. So these are the rights which is associated with the copyright. So that's why we call it as a bundle of rights. So once you register, you get you get so many rights which you can work on your copyright. But here, one thing is, as soon as your content is being published, you get an automatic registration. It's not necessary you have to register under your legal terms. But when do I need to register is, if I have a legal registration, if someone is copying my work, there's an infringement happening, then this legal registration will play an important part and will help me to get the revenue of my infringement, which I have lost, but the other person have gained it, right? So when I legally register it, I can call for an infringement suit, and I can sue him and get the money back. The profits which I lost, I can get it back. So what is the validity here is the lifetime of the author plus 60 years. After the lifetime, you have an additional 60 years, and automatically this is a very long term of validity, and there's no renewal option in this copyright. And next is your trademark. So what is usually a trademark? So by the word itself, you can understand it's a mark used for trading purposes, trade, which we call it as business now. So this mark is used to distinguish one person's goods and services from the other person goods and services. So what can this mark be? It can be a single word. It can be some signs. It can be some logos. It can be some colors. It can be some shape of a good, some packaging, or now even the smell and sound of that particular part, it's been can be trademarked. So for sound, if you have the Netflix sound, the Vodafone sounds, all this been is trademarked. And even the smell, the smell of the soap with some blueberry smell soap, all these are being trademarked. But however, these are very niche area. There's so many restrictions where the sound and the smell can be trademarked. And the color, shape of the goods, you'll understand. For example, if you take a Coke bottle, so when you take a Coke bottle, the shape of the Coke bottle itself is a trademark. Then the Coca-Cola, the brand name is a trademark. So in one single product itself, you can have multiple trademarks. And that the brown color, the device mark, you'll have a sticker, right? The label, Coca-Cola, on the red color label, you will have the Coca-Cola on white script. So that is also can be, that is called as a device mark or the label mark. The whole together can be trademark. Even the caption, say, just do it. If you take Nike, just do it. That can be trademarked. So you have various parts of a particular product which can be trademarked. So one product, there's multiple trademarks available. And what is the validity? It's valid for 10 years and from the date of the application. And since it's dealing with the business, there's no limited period. Every 10 years you can renew it, and you can keep it in the public, you can keep it in the restricted domain until you're in the business. Because the brand name is very important, right? You can't lose your brand name for a limited period of time. So this is called as a perpetual renewal, where every 10 years you can keep on. So you'll be seeing these marks on your products. So for example, TM. If there's a product and if TM has been applied, which means trademark has been applied and application is being given, but it's not registered. And if there's a symbol on the product with a circle, inside the circle there's an R, then it means a registered trademark. And SM, which is a service mark. So like here, goods or services, it's going to distinguish goods or services. So if you take a Coca-Cola bottle, it's going to be a good. But if you take a company like Infosys or Tata Consultancy Services, they are a service providers. So they'll be having these kinds of service marks. Swiggy, Zomato, all these are called as service providers, and they'll be making use of the service marks. And next kind of an IP is your geographical indication. But the first 4 IPs, like in an educational setup, is very important. So when you take a invention, when you're coming up on an invention, one inventions can have multiple IPs. So if you're coming with a product, you can apply for a patent. If that particular product has an appealing look, you can go for a design. And if there's a name for that particular product, I can trademark it. And if there's a software code involved, or if there's a user manual, then I can go for a copyright. So you have to look, when you come with an invention, you have to look for applying multiple IPRs. Now, you shouldn't restrict to one. You shouldn't restrict to one kind of IPR alone. So this is multiple IPRs for one product. It's available. And the next one is geographical indication. Can you all name some GI-based products?
GI-based products means our
in Tamil Nadu also, there's so many GI products.
Ma'am, jasmine flower also.
Yes, Madurai jasmine flowers. It's have a GI.
Then Erode Manjal also taking.
Exactly. Erode Manjal, Kanjipuram silk, Kovilpatti, Kadla Mittai.
These things, sir. Yes, ma'am. Yes, ma'am.
Yeah. So all these.
Panchamritam.
Exactly. All these have GI indications. So what is this GI indication? So there is 2 kinds of products which can get a GI indications. One, it should be related to that particular origin. That is, that the soil or the climate or the environment has to contribute to that particular product. Or in that particular origin only I can manufacture. Say, for example, Nilgiris tea or Darjeeling tea, it's restricted to its climatic condition and the soil which is there, right? So these products have specific geographical origin. But when you take Kanjipuram silk or Tirupati laddu, they are manufactured or the produced in that particular place. So, but they don't have any sign with the origin of that particular thing. They are produced or the manufactured there. So that is also a GI tag. This is called as a community right. It's not given for an individual, the whole community, because there'll be many producers and manufacturers who's been you will be manufacturing this Kanjipuram silks and who'll be manufacturing Kovil Patika Lamitai, and who'll be growing there'll be so many estates who will be growing these Nilgiri tea, Darjeeling tea. So this will be a community right, which will be shared by that particular community. And again, like trademarks, it is 10 years and can be renewed perpetually. Because again, this is a kind of a brand, right? You can't leave it. You can't give a very limited period of time. So again, it can be renewed every 10 years. And the next one is plant varieties. So usually when you take in US or European countries, there are versions where we can protect the plant itself under patents, but India doesn't allow that category. So there's a separate act which allows for the protection of these plant varieties. There's something called as farmers varieties or the breeders varieties. So these can be protected if it follows some criteria. It has to be little distinctive, and when it is growing, it has to be uniformly growing, and it has to be stable. If it's growing for like for 20 days, it has to be stable. So if it follows these criteria, they'll be protected on the plant varieties, and usually the term varies from 15 to 10 years based on the growth and what kind of seeds or what kind of material or what kind of product is being protected on the plant varieties. The term will be varied around 15 to 18 years. And the next one is semiconductor design. Again, in patent, there is no provision to protect the design, the layout of your IP chips. So again, the government came up with a new act, which is called as a Semiconductor Design Act. And this design act, it has to be, again, it has some criteria where it has to be original, and it should be capable of distinguishing from the other layout designs. And you can protect it for and this validity is for 10 years. And this exclusive right is for 10 years.
Sir, please switch off your mic, sir. It is disturbing for madam. Sir. Sir, Mrs. Siva, sir, please switch off your mic.
And so mainly where we can use it, because now we know the semiconductor design is one of the booming sectors. Similar to AIs, the semiconductor sector is also very booming. And all these dielectric designs, metal designs, and IC designs, all this can be protected under the semiconductor design. So the next kind of IPR, which is called as a traditional knowledge. So there's a story behind this traditional knowledge. What happened? US and UK, what they did is, for example, we'll take the turmeric story. US patented the concept of turmeric applying for a Hundiling property. So this you all know, generation by generation, our ancestors has passed on this information to us. So what happened? Then India contacted the US government and said, this is a traditional knowledge which we are passing it down generation on generation, because we know turmeric has Hundiling properties. So this cannot be patented. And there was a court case, and we kept all the evidences where the turmeric were used for the Hundiling properties, and finally we were able to revoke the turmeric patent. Similarly, the neem patent, where the neem has an antibiotic property, which was filed by in the UK court. And again, we were able to, with all the evidence, we were able to revoke that neem patent also. After this, what happened? The Indian government felt that there should be some way to capture all these traditional varieties and keep it into a library. So since keeping it in a physical library, which is not possible, so they came up with something called as a digital library, and they named the digital library as Traditional Knowledge Digital Library. So this library has, it's a vast database dealing with India's rich traditional knowledge, mainly focusing on Ayurveda, Siddha, Yoga, all this. And this, as it is, cannot be patented anywhere. But if you take this traditional knowledge and apply your input into it, say I'm having some composition, say I'm having a neem, and neem has some wound yielding properties, but in particular composition with turmeric, some composition, composition of neem plus B composition of turmeric can be used to solve a C problem. Then I can go for an applying a patent. But as it is, it's like a community properties. India owns it, and it's a community properties where we cannot patent it, where individual cannot patent it. So, but however, if they can make take the available knowledge, they can apply their knowledge over it, and then they can take it for the patenting processes. And the last one is your trade secret. Again, anything which cannot go in for a patent, you can go for a trade secret. So there's a very niche concept between the patent and the trade secret. So what happens here is anything which cannot be easily reversed engineered can go for a trade concept. And where you don't want your business validity is not only for 20 years, it's going to be longer than the 20 years. Then I can go for a trade secret. Then I can protect it under the trade secret. And if there's a strong NDA policies, that is because your employees will be protecting, will be using that formula, right? So if there's a strong non-disclosure agreement between the employer and employee, then you can go for a trade secret. So whatever you cannot, whatever you don't want it to protect it under the patent, you can go for a trade secret. But one thing here, one disadvantage is it, like patent, we don't have any specific statute for protection. So it's been protected under the
Ma'am, your presentation is interrupted, ma'am.
Yes, sir. So, is it audible?
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Yeah, anything which cannot be protected, anything which you don't want to protect it under the patent, you can go for a trade secret. And again, there'll be some criteria. What is the economic value and what is the reasonable effort you'll maintain, you'll keep it to maintain secrecy. All this will be analyzed. So in India, we don't have a separate statute like patent, and it will be protected under the contract law. It's a common law. It will be protected under the contract law. But again, US and UK have a separate trade secret legal procedure itself, which can be protected under that particular statute, where India doesn't have. And here, example, if you take Coca-Cola, the recipe for the Coca-Cola, it's been kept as a trade secret, and also a part of a Google search algorithm. Even though the Google search algorithm, most of the parts it's in open source, the very secretive part is being protected under the algorithm is being protected under the trade secret. KFC recipe, it's also been protected under the trade secret. These are these are the major big players who have protected their business statistics under the trade secret. And data, as I said, it's not been included into the IPR, but there is talks on including the data into the IPR list. Since, as I told you all, the data, everywhere it's data now. So if it is you need a data set to train your AI, you need a data set, and that AI can be used in various applications. And there's so many our data, personal data, which has been captured and used for many other processings. Our medical data is also out, and it is being used for the many other research works. So the government is coming up with a law where you have these data privacy and the ethical use of the data has to be maintained, and how to protect the data under an IPR also. So the talks is going, and very soon we'll be seeing data into a IPR list. And this is an overview of the IPs which we saw. And these are the major kind of the IPs and what is the purpose. So here you can't go and protect the aesthetic view of the product under a patent. Right. So under particular act, the particular purpose will be protected. So this is the overview of your types of IPs, and these are the durations. For patent, it's 20 years, and design, it's 10 years. This is the recap of what we saw. So, for example, take this mobile phone, and how many, what and all you can protect it under the patent, copyright, design, and trademark.
Designs, logo, and
logo will be a trademark. The Apple logo is a trademark.
trademark. Okay, ma'am. Okay, ma'am. You can ask, ma'am, what you can.
No, what aspect of this mobile phone can be protected under which IPR?
It's under product, maybe, ma'am.
Yes, the patent. You can go for a product patent. Yes, definitely, sir. The look and feel of it. See, if you take, it has 2 cameras behind, it has volume button, it has a power button. All this can be protected under design. The user manual of this particular mobile, how to use this mobile on and charge, all that can be protected under the copyright. And again, the Apple logo, it can be protected under the trademark.
Trademark. Okay. There is no secrecy. Secrecy is technology is not patented. It means IPR, not in IPR. Technology. The technology used in Apple is not in IPR, ma'am.
No. It is patented. The functionality of the phone, the OS of the particular, the operating system of the phone, all this will be patented. It's patented.
Okay.
So we saw the different types of IPRs and what can be protected under the different types of IPR. Say now I have an invention. So that invention, I'm planning it to take it to a startup or MSME, or I'm taking it to an entrepreneurship. So now what I have to think in respect to the IP, and how do I take this IP to a startup? So first I have to analyze whether my invention truly solves a problem. So this is called as an invention problem fit. So you have to identify what is the problem in the existing system, and you have to truly solve that, and then take it to, and then you can take it for the patenting. And the second one is my invention market fit? Say for example, I have there's a market need for my invention. For example, I have developed an invention. Say for example, I have a charging system, a battery charging system, which charge within, usually it takes 2 hours for charging, but my invention uses 45 minutes only for charging. I save at 15 minutes time. So I call it as a faster charging system. So, but is it a market fit? So I have to analyze it. Just a 1 hour and 15 minutes gap will be a market fit. Will it give me a market entry? Can I take my product to the market? So I have to analyze whether it's a market fit. Next is patent claim fit. So as I told you all, in a patent, the claims is very important part, which gives you the monopoly or the rights. So I have to understand that whether my patent claims are strong enough that I can use this invention and take it to the market, and I can also make a revenue on this market. So my invention has to solve a problem. Also, that problem has to be fitted into the market. And also, when drafting a patent, my patent claims has to be strong enough so that I can fight around the competitors. So what happens here, if even one of the if one of these fits doesn't, if it is lacking, you cannot take it into the market. There may be some failure in the, there may be the same, it can be a brilliant invention, but even if one of these fit is lacking, you can't take it to the market. So it has to be technically relevant, commercially be viable, and also legally strong to proceed. So when you are planning for a business, these are the very important aspects you have to think. Technically, it has to solve a strong problem, and it has to be commercially viable. So it has to be fit into the market. It has to understand the needs of the market. And also, the patent, you shouldn't take it for the grant. You have to protect it under your patent claims has to be strong enough to fight against your competitors. So these are the main fits when you have to consider when you're taking your product to a business area. So these are the few common pitfalls which we find in the patent process. So what happens is, again, the first I told you, we do journal publications more than patenting, because we think patent processing is a long process and it is a lengthy process. It's a time-consuming process. It's very costly. But so we go for a journal publication rather than filing a patent. So what happens? A journal publication doesn't give you a revenue, or doesn't give you a legal protection, but whereas your patent gives it, right? So always make sure you file a patent and then take it for your journal publications. And when you're drafting your patent, when you do it for yourself, or when you're giving it to any other person, make sure the claims are very strong enough to fight against your competitors. And also, the details which you're giving in your patent description, it has to be very clear. The best working method has to be submitted for the description of your invention. And also make sure if there's any future modifications or improvements, you can make sure you have to include it in your patent application, so that someone doesn't come with that small modification and claim, I have made this modification, so I'll get a new patent. Excuse me. So these are the things you have to make sure during your patent processes. So what is the benefit of patenting, or what is the benefiting of getting your IPRs? One, first and foremost, you get a protection, a legal protection. Even someone infringes your product, you can pull them to the court, you can sue them, and you can also get a book of accounts. And it's a monopoly right. Even if it's for 20 years, it's your invention, your time period where you can make use of your invention. You can generate revenue of it. Either you can make a startup, or you can license it to someone who has that infrastructure to develop your product. You can definitely license to them. And when you're going in for a startup, when definitely if you have a patent that has been valid more and it will attract more investments. And also when you have a patent, you have 20 years sustainability. And here you can use as a defensive strategy. So definitely you can work around your competitors, and with your patent you can definitely you can stand ahead of them. That is a defensive strategy. So these are the so many benefits where your patenting gives you over your publications, and which helps you and make you on your revenue generations, which is most important part of your invention. You have spent so many times your time and your resources over your developing an invention, and finally something we get out of it, right? A kind of a revenue, a kind of recognition, all that is being achieved in this when you patent it. So when you have some idea in a mind, make sure you formulate a strategy. You have to analyze an idea and conduct a patent search. Like you have so many free patent search websites like Google Patents, eSpaceNet, free patent online. Conduct a patent search and see what is patented already and what is not patented. Then also analyze your competitive strategies. Then go for protecting your IP and take it to your market. But make sure timing is very important. You have to be always very quick in deciding whether I have to go in for a patent so that no one overtakes me in your protecting the patent, because patent is first come first serve. So only when you go and file your patent, you're the first in the market, your patent is protected, so you will get the right. So the timing is very important in strategy when you're formulating an IP. So if you're missing a time, someone else may develop the same product and take it to the market, and he may get a revenue, right? So timing is very important. You have to quickly decide whether you have to go for a patent or not. And these are few startups which have worked on patents. That is, these are built on the patents. So when you take Aether Energy, it is one of the IITM alumni. They have filed 151 patents worldwide. And based on these patents only, they have built their Aether Energy. Initially, they wouldn't have filed 151 patents. With 2 or 3 patents, they got up with the EV sector. They got into and based on the developments, they keep on filing, and they have a huge number of patent portfolio. Next is Cure AI. Again, medical imaging technologies like your CT MRI scan, they are using a AI based scanning the images, and based on they have a patented technology, and they also building a patent portfolio on how to diagnose it and how to improve the medical imaging processes. And the next is Sylagenix. It's also palmad setup, which is used for drug discovery technologies. Again, they also have a patented technology which uses computational chemistry, machine learning, which discovers new drugs, and also that improves the drug development processes. Again, you all know Paytm, which we are using it. It has also been built upon the patented technology, like the biometric authentication, how the payments are encrypted and sent from the sender to receiver. And it has a machine language to streamline the patented processes. These are very few which are built on the patented technology. There are a lot more startups which are coming up, which have a patented technologies, and based on their patented technologies, they are taking that particular product to the market. So again, this is a benefits that the IPR can offer. So again, you have a recognition, you have a competitive advantage. If you have definitely an IPR, if you have an IP right in your hand, anyone can come and invest in your company. You get a competitive advantage over your competitors. You get some financial gains. And these are the IP filing statistics we have got only from 2023. We have almost, India has almost filed 65,000 applications. In 2024, we have crossed a lakh, which soon the statistics will be released. Again, design, we have filed around 31,000 in 2023, which we have crossed to 60,000. We have doubled in 2024. These are few statistics where we see how IP filing is helping the India in innovative space. The statistics says that. So make sure like you take charge of your creations and protected it, and so that you don't lose the advantage of getting your product to the market. Yeah. Thank you for your time and patience. Like, if you have any questions, we can start with the questions.
Ma'am, can I fill the patent through online?
Yes, sir. There's online filing of your application. So you have something called as an e-filing of Indian Patent Office. You can Google it. It will take you to that space, and you can file your applications. But there are few forms and few necessary documents which has to be submitted.
If there is any format for applying IPR, ma'am?
For patent, yes, sir. It's very similar to your journal publication. There is one document which is called as in a Form 2, which has to have your title, detailed description, diagrams, and the claims and abstract. So similar to your journal thing, but there'll be something called as a claims, which is very important in patent. You have to follow that format, and you can apply it. There's something called as an impasse.
Because if I want to
Impasse.
publish, ma'am?
This is
Okay.
called as an impasse. I think a screen visible to you all.
Yes, ma'am. Yes, ma'am. In pass. Yes, ma'am. Okay, ma'am.
Impasse. This is the Indian Patent Office website. So you can go here and search. So you can search here. You will get the documents. So this is a repository.
Okay, we are typing in artificial intelligence. Okay, ma'am.
Say something. You can give a title, and this is your article repository of where we are all the people have submitted the patent. So you can go here and check.
Okay, ma'am. Because in journal publication, they are providing the templates like that, ma'am. But in patent, it is very difficult to file a patent, ma'am, because there are so many forms, ma'am. Which form is correct for which application? We don't know, madam. That's the main reason we don't file. We are
Yes.
approaching some agencies for filing patents, ma'am.
Okay. But they would have taught you, right, what and all form is necessary. So this is the thing. Usually form one is necessary. It will capture all your details of your inventors and applicants. And form 2 is about your inventions. Form 5 is your inventors has to declare the patent. If you're suppose you're assigning it to your employer, then you have to give a declaration. So very basic. If you go through one or two set of this, you'll be able to view it.
Okay.
So if you
Form
go
one-
through this,
Yes, ma'am.
yes, sir. Tell me.
So form 1, 2, and 5 are mandatory, I think. Am I correct, ma'am?
Yeah, 1, 2, and 5 are mandatory. And suppose if you need an early publication, Form 9 is required. And for examination, now it is 31 months. Within 31 months, Form 18 has to be submitted. But at the time of filing, 1, 2, and 5 is mandatory.
Mandatory. Okay.
So 9 and 18, you can submit it later. 9 is optional. If you want early publication, you can go. Otherwise, you can go with it will be defaultly,
Normal.
it will be without request, it will be published.
1, 2, and 5 is enough. Okay. What is the minimum period for ma'am?
For which one, sir?
For patent IPR, ma'am?
Actually, we are getting grants. Usually, since we are following expedited route in IITM, we get it. Many of our applications are we'll be getting a grant within a year, but it takes up to 2 or 3 years maximum.
Maximum. Okay.
There's two
Is it
rules. Honestly,
ma'am? Sorry for disturbing.
no, there are two rules. Yes, sir. Sorry.
Okay. Okay, no problem. Madam, while I am filing the patent, it is e-signature is mandatory. They told that, ma'am. Is it mandatory for filing IPR through online if e-signature is mandatory, ma'am?
Yes, sir. Now e-signature is mandatory. Even as an inventor, it's mandatory even for you all. Or if you're filing it through your college or any of the patent agents, they'll be having the e-signatures.
Ma'am, digital signature or e-signature, ma'am?
E-signature, anything is fine.
Anything is fine. Okay. Okay. Thank you for more clarification. Thank you.
Dear participants, if you have any query, kindly unmute your mic and ask Madam. Madam is ready to respond to your queries, ready to clarify your queries. If you have any doubts or clarification, kindly unmute your mic and ask the question.
There's a question in the chat, fees for filing patent. Initial filing is 1,600. But if you wanted an early filing, because as an educational institute or it's an individual inventor, it is 1,600. If you want an early publication, then for that Form 9, you have 2,500. And early examination, again, it will be 8,000. So around 15 to 16,000 will be your filing charge. And there's one more question. Publication patent can be filed by an individual. There's nothing called as a publication patent. So it is a patent. So where everyone wants to take it for a grant. So in that one stage is publication. So it can be filed by individual, anyone, an individual or the assignee, like employers, your colleges or MNCs, they can apply for your patent, or your legal assigner, they can also apply for the patent. Definitely, yeah, it can be filed by your individuals. There's one more question, like whether PPT has been filed. Can Gautam sir can unmute and ask what is this question about?
Gautam sir, Gautam PhD sir.
Good evening, madam.
Good evening, sir.
Madam, this is Gautam from Trichy.
Yes, sir.
Madam, actually, one of my friend is acting as a patent agent, madam.
Okay.
In our college.
Okay.
But he told whenever you have a PPT, we have registered for we have filed for something, ma'am. I can't understand what they're trying to say, whether they are in IPR or trademarks or patent. So that's the thing, ma'am. I asked this question to you.
PPT.
PowerPoint presentation.
Usually,
it may be a trademark.
It can be taken for copyright alone.
Okay.
Yeah, you can take it for the copyright, but not for the patent.
Okay, copyright.
Yeah, it can take it for the patent because it's a expression of your copyright is usually the expression of your ideas. So you'll have a different format of data put up in your PPT, right? So you can take it for a copyright.
So how will going to apply a copyright, ma'am? Is there any procedure for copyright?
Yes, sir. Yeah, there is a procedure, but it doesn't have any examinations and all. There's a copyright office. You have to submit a few forms there, and what you're copywriting it. You have to. There's something called as in a form 14, and
Okay.
you'll have your PPT. You have to sign it. Those who have created the PPT, you have to sign it. All that copies have to be filed in the copyright office. There's online provision is also applied.
Whether it is easy, just like you previously told about the patent filing, ma'am, or otherwise it is very difficult.
No, it is easier. It is easier than patent filing. There's
Oh,
no
through-
examination also. You
Okay.
can e-file it, and they may if there's any discrepancy, they may send a letter. Otherwise, they'll register it under the copyright.
At what portal we can check for the copyright information, ma'am?
You just give us a copyright office. So there will be an e-filing copyright in India. So you'll
Okay,
have a link which will you taken for the e-filing.
Okay. Thank you.
Vivek Prilla, fees, like I'm not sure about fees. So usually it's form 14 and whatever the forms, and you'll be giving the material which you're going for the copyright. So only one form along with the what is the material you're going to copyright it, register it, that you'll be submitting it for the copyright registration.
Participants, if we have any more questions.
And Vivek Brilla has asked how much time it takes to get a copyright. So usually around 6 months to 1 year we get it out. If there's some discrepancies, then there may some delay. But if there's any discrepancies, then you can immediately get it around. Within a year, you'll be getting the copyright registration. Because there's no substantial examinations, so they'll be giving you to. It'll be very faster process only.
Ma'am, I have a question, ma'am.
Yes, sir.
Ma'am, is there something called a design pattern?
There's we don't call it as a design patent. It's called as an industrial design.
Okay.
So only the look and feel of the patent, the particular product, you can take it to the design registration.
Okay. That's also easy compared to the patent.
Yes, definitely. It is very easy. The procedure is very easy than the patent.
Okay. And also I'm receiving some information, some other group, they are mentioning that the UK design pattern like that.
There is in US they call it a design patent, they call it as, but in India we call it as an industrial design only, sir. There's in Germany and all, they call it as a utility patent and all. So without examination, they give you a certificate. So within a 6 months or 8 months, you get a certificate itself, grant certificate itself.
Okay. What is the use of that, man? Can we use that pattern in India for like credentials? Like if I have filed a pattern like that, can we show that in India?
In India, no. Is a patent, anything is territorial right.
Okay.
You can enforce it in India only when you protect it in India.
Okay.
Maybe for academic credentials, we can use it. See, we have thing, but enforcing it in India, it's not possible.
Thank you. So, dear participants, if you have any query, we can unmute your mic and ask. Otherwise, we will go for the feedback session and a screenshot session. If anything you want to ask from madam, kindly unmute your mic and ask to madam. I think there is no question, ma'am. Thank you very much for sparing your valuable time with us. The session was very wonderful and highly informative. And at the outset, first I would like to thank, because we changed the timing of the session from 2 to 3:30 due to some local program at our institution. So you readily accepted our request and changed the session timing to 4:30 to 6. Thank you very much for that. And on behalf of the Murugappa Polytechnic and on behalf of the Department of Mechanical Engineering, our sincere thanks to you. It's a wonderful session. Thank you very much, ma'am.
Thank you, sir. It was really engaging session for me also. Questions were asked and like they were answering also. It was very engaging. Thank you, participants. Thank you, sir.
Thank you. The dear participant, kindly switch on your camera. Let us have a screenshot session for this session. For 1 minute, kindly switch on your video camera. Thank you very much. Thank you all the participants. Now the final session's attendance and the feedback link will be posted in the chat box. Kindly take your time. It takes around 5 minutes time. Kindly fill the feedback map. So based on the data you are providing only, the certificate should be generated. So kindly take some time and fill the details correctly. Thank you.
Thank you, sir.
Thank you very much, ma'am. Thank you.
Sir, I think the link is not opening, sir.
We'll check, sir. We'll check, sir. No issue, sir. The same link, I think it will be working. I will check again, sir. So kindly check, sir. It will be working, sir.
Sir, any participants, is it working, sir, link?
Someone can confirm. So I think the form will be working.
Yes, sir, now it's working, sir. Now it's working.
Okay, okay. Thank you. Thank you, sir.
Sir, actually, it's working, sir.
Okay, sir. Thank you. Thank you. So thank you all for joining with us for the last 2 days. Please stay in the group. We'll be sending the details of certificates by day or the day after tomorrow. And we will be posting regular updates about our activities organized by our college as well as some interesting information about FDPs. Please stay on the group. Thank you.